Green card denied? You could face deportation court in 2025. Here's what to know. Denied a green card in 2025? You might not just get a rejection letter, you could end up in deportation court. Yes, seriously. USCIS is cracking down, and a simple denial could now trigger removal proceedings. Stay with me, because what you don't know could cost you everything. Under the latest policy changes introduced by USCIS and DHS, green card applicants who are denied due to ineligibility, fraud concerns, or status issues are increasingly being issued notices to appear known as NTAs. An NTA means you're being referred to immigration court, where a judge will decide whether you should be deported. This isn't just a threat on paper. In 2025, enforcement has ramped up, and the backlog in the immigration court system is no longer a reason for delay. Cases are moving faster, and the stakes are higher. So what's triggering these NTAs? It's not just serious criminal offenses or fraud anymore. In some cases, simple mistakes on an application, overstaying a visa, or being out of status when your green card is denied can be enough to put you at risk. For example, if you applied for a green card while on a temporary visa and your application is denied, you might lose your lawful status, and that could make you removable. Even those with no criminal history or who have lived in the US for years are not automatically protected. That's what makes these changes so important to understand. It's no longer just about getting denied, it's about what happens next. And for some, that next step could be a courtroom, not another application. But don't panic just yet, there are steps you can take to protect yourself. First and most importantly, don't file anything with USCIS unless you're 100% sure you're eligible. If you're not certain, talk to an immigration attorney before you submit your application. A single form error, missed document, or misunderstood question can lead to denial and now, potential deportation. Second, if your status is expiring while your green card application is pending, make sure you apply for extensions, work authorizations, or other protections available to you. If you fall out of status during the process, you're much more vulnerable if the application is denied. Third, know your rights if you do receive an NTA. Getting referred to immigration court doesn't mean automatic deportation. You have the right to defend yourself, present your case, and in many cases, apply for relief. This could include adjustment of status, cancellation of removal, or asylum, depending on your situation. But time is critical. If you get a notice and ignore it, you risk being ordered deported in absentia, which is much harder to fight later. Also, be aware that USCIS and ICE are now sharing data more actively. That means if your application raises red flags, it might not just result in a denial, it could land you on ICE's radar. The agency has more tools in 2025 to track applicants, monitor status, and initiate enforcement actions than ever before. All of this makes one thing very clear: applying for a green card is no longer just a paperwork process, it's a legal battle. And you need to treat it like one. Know your eligibility, protect your legal status, and don't go it alone if your case is complicated. If you found this information helpful, hit the like button and share it with someone who might need to hear it. Don't forget to subscribe for more updates on immigration policy, green card tips, and your rights in the US. And if you have questions about your situation, drop them in the comments. I'm here to help explain what these changes really mean.